Please see the board also, my lord, composition of the board. Please see the board also, my lord. Kindly have a look at the board at page. Please see the board also, my lord. Kindly have a look at the board at page 20. Please see the board also, my lord. Kindly have a look at the board at page. We have one page. Board 28. Kindly have a look at the board at page. We have one page. Same board 28. Kindly have a look at the board. Somewhere third from the 28. Somewhere third from the 28 bottom. Somewhere third from the 28 bottom. Somewhere third from the 28 bottom. Provided also that the elected members of the board, I'm sorry. Provided also that the board shall have at least one member each from Shia, Sunni and other backward classes amongst the Muslim community. I'm sorry, Upar. No, this is a new development, my lord, which is given. Earlier it used to be only Shia or Sunni. Now, my lord, other sects of Muslims also will have a representation. It is inclusive. Now it's more inclusive. Provided further that 2 of the total members of the board appointed under this subsection, excluding ex officio members.
This way, according to you, will be interpreted the same way as the other provisions.
I'm not saying. That's how the ministry has placed in writing before JPC and Parliament also. Now, kindly see, my lord, on page 40, my lord, which is now deleted. On this, the report of the JPC, it's in public domain. I presume, Lord, everyone must have read. You will have a look at only one para of the JPC. I'll place everything, my lord, on record. My lord, everything has a logic, rationale, and a purpose, intent behind it. My lord, can you have a look at it?
That's we have understood. You have argued that, we have understood that. We have understood your argument that only 2 plus ex officio out of the board and the council.
And, my lord, one more, my lord, salutary function according to me, that 2, even from amongst the Muslims, would be ladies.
That's fine.
It has become more inclusive.
That's fine. That's good.
It has become more inclusive.
Your argument is to be accepted, Mr. Mehta. In clause C, why do you specifically say that these members should belong to the Muslim community?
It has continued from the beginning.
If your argument is to be accepted, you didn't have to mention that. This proviso could have taken care of it. Why do you specifically say under clause C that these are to be Muslim members? You leave the others without any indication.
Because there is
the proviso 2 will be Muslim.
No, there is a choice. Bro. Sometimes, at times, suppose, my lord, in the members of legislative assembly, you do not have a Muslim member. Then, my lord, there is a choice. My lord. That's why.
It could go beyond 2 also.
Yes, my lord. It would be but more than Muslim from amongst the Muslims.
Non-Muslims, it could be more than 2.
No.
If they're not available.
Therefore, I wanted your lordships to see our response to the JPC. Our means ministry's response.
Because we'll have to go by the wording of your section.
I'm saying.
Can't argue contrary to the language of the section.
Lord, I am saying, my lord, that this is how it is read.
Takes of Muslim members only under clause C.
Lord, section says the same thing, my lord.
Only under clause C you speak of Muslim members.
My lord, there is a flexibility, my lord.
So the rest of the members could be non-Muslim.
No, but not more than 2. My lord, proviso will have to be read with 1 and 2, A and B.
proviso does not say that only two members shall be. Further, that
I'm
two of the total members shall be.
That is what, my lord,
Your argument is militating against the combined reading
It
of
is-
both these.
it is not. But this was the confusion before JPC. Therefore, kindly now, my lord, for my satisfaction, have a look at what we said before JPC.
Read your JPC minutes into the section.
I'll file an affidavit, my lord. That's how, my lord, it is understood.
Affidavit will not change the statute.
Another thing, my lord, I must tell your lordships. All council, this council or Waqf boards, till they complete their tenure, he will complete the tenure. Whenever the new body is to be formed, this will come into effect. What the section says.
The existing board and the council.
Obviously, my lord, nobody goes
What is the term of the council as of now?
different, my lord, different.
There will be different council for different
It's not different boards.
boards will be different. Boards will be different because boards are, Delhi Waqf Board is there. There must be other Waqf boards.
Please, sir,
One minute.
this is a matter being argued by lawyers.
One minute. As far as council is concerned, when is the term of the council coming?
Lord, I can take instructions, my lord. If somebody is shouting, there is no council, but I can't, my lord, answer like.
There's no
There is
council.
no council in existence today.
So 2.5
For 2.5 years, there's been no council.
food provider, sir.
Yes.
And, okay, now, according to you, therefore, there are ex officio and only two other members can be non-Muslim.
Which can be in A base, A and B
And
category.
other members will be always be Muslims.
That's what we say.
Section 2, was saying that a decree has been nullified. It only says that if there was a trust which has been declared.
No, please, that will have its own consequences. Oh,
Lord, my lord, I will answer your lordship, my lord, why that decree, etc. has come. According to me, my lord, doesn't seem to be for any particular, to my lord, nullify any judgment. It's an empowering provision that if I am a Muslim, I don't have
no,
to.
but then there's a difficulty in that.
ಮಗ ಚಿಲ್ಲಿಂಗ್ ಅಂದ್ರೆ
ಕಬ್ಬನ್ ಪಾರ್ಕ್
ಸ್ವೀಟ್ ಅಂದ್ರೆ
ಮೈಸೂರ್ ಪಾಕ್
ವೆದರ್ ಅಂದ್ರೆ
ಪರ್ಫೆಕ್ಟ್ ಫಿಟ್
ಸಿನಿಮಾ ಅಂದ್ರೆ
ಸೂಪರ್ ಹಿಟ್
10 ಮಿನಿಟ್ಸ್ ಅಂದ್ರೆ
ಬಾಯ್ಸ್ ಬಿಗ್ ಬಾಸ್ಕೆಟ್ 10 ಮಿನಿಟ್ಸ್ ಅಂದ್ರೆ ಬಿಗ್ ಬಾಸ್ಕೆಟ್ 10 ಮಿನಿಟ್ಸ್ ಅಂದ್ರೆ ಬಿಗ್ ಬಾಸ್ಕೆಟ್
Big Basket, delivering in Bengaluru and everywhere in 10 minutes.
No, that's not correct. That's not correct. That's not correct. My lord, what is meaning? It means is. What it means is this, even if it is a Waqf, if I want to convert it into a trust and come out of this trust Waqf Act, it is open for me. It's an enabling provision. If today I am a Muslim, I want to, my lord, do something for charity, I don't have to make Waqf. I can make a public trust or any other trust. It's recognized by 5 judges in a Waqf Act case.
Can't rewrite the past. Can't rewrite the past, say even 100 years back or 200 years back.
Nobody is rewriting the past. My lord, kindly have a look at my lord once again. It's not rewriting the past, it's an enabling provision. Provided further that nothing in this act shall, notwithstanding any judgment, decree or order by whatever name called, apply to a trust established before or after the commencement of this act.
Before also, not, I can understand after commencement, but not before.
If it is a trust already before commencement, it will not apply to which is a trust already when in 2025. So trust would not become a Waqf because it is by Muslim for some Muslim religious pious charities. Lord, kindly have a look at, Lord, kindly read once again, Lord. Provided further that nothing in this act shall apply, Lord, so and so, apply to a trust by whatever name called, established before or after. So trust has to be established before or after commencement of this act, or statutorily regulated by any statutory provision pertaining to public charities by a Muslim for purpose similar to Waqf. Lord, suppose in 2022, some trust is created by a Muslim under the Public Trusts Act, my lord, nothing would prevent, my lord, this act will not come into force.
No, but this Public Trust Act is something which is state-wise. It's never been, but we don't have all India public.
Correct, my lord. It can be Indian Trust Act.
There have been instances where people claim trust, they intend to, give it really to the God, the Allah. And therefore, those have been always treated as Waqf. Even I'm, look, if I'm not.
My lord, I can show a 5 judgment. I want citation. My lord, I can give 5 judgment of Hyderabad Nizam.
Lordship, this is a very simple answer, if I may.
Please, let us continue as lawyers. Let's continue.
Then issue notice, file your replies.
I'll file my reply. But my lord, I must, only a minute.
1 minute, please.
Mr. Jain, Mr. Jain, if you don't mind, sir, there is an answer to your lordship's question in the judgment of 5 judgments, 63-1 SCR 469, that there can be a trust by a Muslim for the same purposes which are providing for Waqf. This issue, this is Nizam, Hyderabad Nizam.
So, but then you undo that. Judgment is not reallocated.
We are not undoing. If somebody has created a trust, it will remain a trust. Merely because it is for Muslim charity, it would not be governed by Waqf. That's it, it says.
Lordship, may I assist? This is a very simple answer, if I may assist, Lordship.
Notwithstanding any judgment to the contrary.
Pardon?
The lordship on the earlier occasion that the challenge to the earlier Waqf Act should have delegated parties to have.
And that is
A very simple answer, Lordship. My lord in Chief Yusuf Bhai Chawala said that the purpose and the intent is the test. Now, this is saying that notwithstanding the judgment, the establishment is the test. So that's what the difference is. Those judgments cited have said that purpose and
These
intent is the
these are the petitions challenging
Just 1
95.
minute.
These are petitions.
Just 1 minute.
Yes, sir.
The orders.
Order at the 4th page, not decided in 2025. 30 years. 22nd March 23 order, where 120 petitions are pending.
But you have withdrawn that petition?
No, it's still pending.
They're still pending.
140.
What's the challenge in those petitions?
95 Act, 1995 Act.
That's a. They are pending. 30 years later, they are pending.
Where the Waqf by user has been challenged in those proceedings.
The work by user has been challenged.
Yes.
And 30 years later, they are pending. That's a good
But
reason.
I did not answer that because I have no difficulty in
Now it's
satisfying the
becoming
lordship.
structurous because
I didn't want to, my lord, show that we are hesitant in answering
pending.
your lordships.
There are still challenges there which will survive you.
Now there are 3 options before us. First is we decide this challenge. Second is we relegate you to a one common high court.
But second should come with a
One
interim
minute.
protection in the meantime.
1 minute.
They have to have interim protection.
Just 1 minute.
The lordship will have to protect us.
That's okay. In part A and part B of second.
Lord, can I say?
1 minute. Part 3 is that we call those petitions also over here and
Yes.
decide this.
I know.
This has to be decided here.
Yeah,
That's
but
pending
it
for
has
30
to be
years.
decided.
Mr. Vikas.
Pending for 30
Can
years.
I suggest?
So we will not be able
No,
to.
there-
Can I suggest?
Question, sorry, just a moment.
Can I suggest?
Question that in view of this amendment act, which is all very sweeping.
Probably many of them have become infrastructure. No, you may have a point. there.
In a petition
where it has not become infrastructure. Right there, but the issue is when the constitutional validity is being challenged, then depending upon our answer over here, they cannot be thrown out.
Lord, can I submit? I have only a minute, sir, please.
Lordship, to hear it here, this will be a very.
Lord, your lordships may issue notice. I'll file a reply within 2 weeks. Kindly take it up on a day-to-day and finally dispose it off. I have nothing,
But then-
Lord, therefore
But what's your 3 situations will you?
Lord, I didn't want to support that position, my lord, because that would show
all these-
I'm hesitant in sustaining this amendment before your lordship.
So please hear it here.
solicitor, your lordship.
All are items. Hear it, your lordship. This is not.
I support him. We'll have to call those matters.
After
Because otherwise
the experience of the 95 Act is good enough, reason why lordship should hear it.
Situation where your
Within
lordship
itself,
supposing set aside this,
my
and those rates are also not considered.
There are several judgments, etc. We will assist your
There's
lordship.
another solution.
Yes.
Within
Mr.
itself, Manoj,
My lord, there's another, so I am appearing in a petition where the old act is under challenge, which we have filed here. So your lordship will hear both
within itself,
dimensions of the
Manoj,
matter and your lordship can
my
decide the whole
essential
matter.
religious practice and
There's an old act, challenge pending in this court.
Yes,
also.
yes.
Everything should be here.
Item number?
within itself,
I
Manoj,
know that this is.
99.
there is I think there is a fresh petition filed.
Yes, it's a fresh petition filed.
95 Act with amendments.
Because the reason is the 1995 Act has not been taken away for the past in respect of certain matters. So both sides of the picture are before the court. Your lordship may hear the whole matter finally because this is a matter of moment. Your lordship may hear the matter finally and decide it one way or the other. So there's no need for calling the High Court petitions. See Rajiv Shankar there, petitioner side. James is Supreme Court. See, only. Say it out.
Where the maximum number of matters are pending. 140 matters.
Nothing will happen there, Manoj.
That's the
And
only.
there is no other, the matters pending in any other item.
Look, last there
Last
can.
year, your lordship will recall the IT rules matter, which was very, very pressing. Your lordship,
The NGAC matters, your lordships transferred all of them to this court.
we can't get a listing of them.
That's right. But NGAC matters, your lordships transferred to this court.
Sent to the High Court, it means that the bar of 32.
Okay.
Most opposite.
Okay, we'll call them.
As your lordship just rises one sentence.
Well,
Now,
he wants
four
status
pernicious-
cumulus.
Four pernicious provisions of status
He wants
cumulus.
status.
3 bracket R, 3 capital C.
I want to argue.
9
an
and one
interim
second,
order.
sir,
I
No,
want to
no,
argue.
9 and 14.
You have addressed us. We'll pass an order
9 and 14.
which we have heard you on different aspects. Order we are passing or whichever interim order we are passing will balance out the.
Lord, can I
3 R,
hear me,
3
my lord,
C,
for interim order?
3 R, 3
We
C.
should be heard, we should be heard on interim order.
1 minute. We have been- 1 minute, 1 minute. The interim order which we are passing is on two counts. Let me put it. We take from part is on two counts. One, whatever properties have been declared to be Waqf.
Registered.
No.
Look, how would
Just
declare?
1 minute.
I declare.
1 minute, Mr. Don't put words into my mouth. Hear my words first.
No, I'm sorry. No, nobody.
Declared by court.
1 minute. Whichever properties have been declared by the court to be Waqf or held to be Waqf.
Yes.
1 minute, please. Will not be denotified as Waqf and will not be treated as non-work properties, whether they are by work by user, work by declaration,
I bow down.
or otherwise.
I bow down.
No, declared by court or otherwise also, which have been established to be one. Number two,
There is
we'll permit,
otherwise.
just 1 minute, please. Just listen before. We have consulted each other. We have thought about something. We are not saying that this nation is so, we can always modify. Two, the collector can continue with the proceedings, but the proviso will not be given effect. And if he wants, he can move an application before this court. We'll modify that. Number two, as far as constitution of the council and the boards is concerned, ex officio members can be appointed regardless of the.
Kindly, my lord, then hear us on interim.
1 minute, 1 minute.
But we have not given.
1 minute, please. We'll hear you. We can hear you tomorrow itself.
Kindly, my lord, have a look at it.
1 minute.
Kindly,
I thought it balances out
No.
it balances out completely your interest also.
so far as boards are concerned,
1
their
minute.
tenure is yet.
1 minute, please. Just listen to the second. As far as the board and the council are concerned, as far as ex officio members is concerned, there is no difficulty regardless of the faith, they can be appointed. But the other members should be members of the Muslim list.
Only a minute. Allow me to answer.
That,
Allow me.
Yes.
The lordships have decided I have nothing.
no, please.
Lord,
That's
as far
why
as,
we're asking
so
you.
far as boards are concerned, their tenure is yet to expire and new constitution.
Why we weren't
There, my lord, because of the order. Because of the order, without, my lord, am I assisting
They
your
were all
lordships
Muslim anyway.
with judgments? My lord, in case of, my lord, Tilkayat judgment,
Okay, when new boards are to be appointed, then in those cases don't.
my lord, then we'll come before your lordships. We do not even,
Okay,
kindly, my lord,
before you appoint a board, then you come before us. Take up a-
kindly, kindly, my lord,
Act coming force now.
only a minute, Lord, kindly a minute.
No, we cannot have this. We are asking them, they have.
But
some
the
objection.
difficulty
If you have
is-
objection, we'll let
Not
it go.
all are public interest litigants. There is not a single board before your lordships, single affected Waqf before your lordships, that I am going to be affected or demolished or removed or something.
Tushar Mehta. So Tushar Mehta, you, on one hand, you are saying all boards are already in place.
Yes,
They have terms which will come to an end after a particular time,
yes.
correct? Okay, we can record your statement that before you appoint any new member of the board, you take up, you can move an
No,
application.
your lordships may say, my lord.
Okay, we'll say that.
Your lordships may say.
Act actually
We'll
says.
say.
Because I have judgments to show, my lord, in Tilkayat, your lordships are aware, 5 judge or 7 judge bench judgment. In Tamil Nadu,
Notice.
only a minute, my lord, kindly allow me to show.
Not all
My
members.
lord, please examine.
Correct statement of section 14 itself as amended. Section
My lord,
14 says elected members.
the Tamil Nadu government, in the case of Archaks, that is Pujari, this honorable court says that Pujari's function is a secular function and government can appoint Pujari.
But we are not on secular functions.
But I am on secular functions. You may not be.
Because you are
It's an administration of property.
very novel.
It's an administration of property issue.
Now it's like nation,
No.
they have done away with elections from the Muslim community.
Being works by non-Muslim can't be secular.
CEOs.
The CEO has to be Muslim.
Lordship
No, no,
may
there is
hear
a lordship, my lord, here, all of us.
lordship may hear us tomorrow, my lord. Then
Kindly, my
We can hear you for 5-10 minutes.
5-10 minutes. Your
lordship may hear.
No, as far as ex parte stay is concerned, it's always an element of discretion.
No, your lordships have
So
only.
you are on caveat, you're not entitled to be heard as far as the issue of notice is concerned. You are only entitled to be heard as far as.
This is a matter which is something different from the ordinary litigation, my lord. This is a matter.
Maybe, therefore we have spent so much time, we assembled.
No, I appreciate it. I'm not critical.
But then it's also a matter, it's a
But
matter of We are all concerned about it. Let's find a solution.
Yeah, correct, my lords.
Lord, can I-
Lordship will find, my lords. I'm sorry, my lord.
Okay, your lordships may, but sometime, my lord, tomorrow. We would like to address your lordships, my lord, on the interim. So your lordships have recently in that election commission laid down the law, my lord, when the statute can be stayed directly or indirectly.
No, we are aware of that. We
We would
have
like
got-
your lordships, my lord,
No,
to
all of us know those judgments. We are also concerned. Normally, there are two rules which apply. First rule is normally when the legislation is passed in order, passed the legislation, courts do not.
Cause now we gonna be gunning it.
Nirvana X for extraordinary sound.
वेलकम सर, वेलकम जी। बिल्कुल 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 सर जी। आप सर, जब श्याम ने काम किया है तो खुशी तो होगी ही।
मेरा नाम मेरी शान, Vista Print.
Central government.
Yes.
As far as the boards are concerned, they have to be constituted by the state government.
I'm interpreting,
But how will you bind the state government? You'll have to pass that on.
I'm interpreting a central law.
We'll record your statement and then pass it on.
Lordship,
And then we have
Can we hear you for half an hour and then finish it off today? Or keep it for
Lordship, we have
tomorrow?
it tomorrow.
tomorrow, not,
I will be extremely grateful if lordship hears us.
kindly have it tomorrow.
For what? Yes.
But two questions, my lord.
No, we
No, no,
can
no.
hear everybody from the other side. We can't hear everybody. We're not going to hear everybody from
One
the.
batsman is brave.
like that, Mullah.
Lord, we have something to assess your lordships.
They're all interveners.
What else is there, Mr.
Lord, kindly allow us, kindly allow us. It's not, my lord.
Yeah, virtually, I thought we had built a consensus between the two sides.
No. It cannot be, it cannot.
Okay. My user is there from 1940s.
Lord, Lord, it,
Right on. Okay, I'm just stating a tentative order.
Lord, your lordships may have it
Lordship may have
tomorrow.
it tomorrow.
Lord,
Don't go on. Your lordship, this will continue like that.
Continue, my lord. It is not a matter, it's a matter of moment.
I thought Mr. Mehta, we thought we had virtually reached a consensus as far as you are concerned. I thought the others were one who was objecting.
I would, my lord,
So we virtually were, what we said, we're going to just reiterate that in our written order, what we spoke.
We have something to say.
No, we have some-
Grateful if your lordship continues the hearing tomorrow, Mullah, then.
very grateful. We can, my lord,
This will just continue in this fashion. Your lordship,
What in this
the essential
fashion,
points are before your
understand, you
lordship.
will
Otherwise,
continue.
you'll also have to answer.
It's simple. We have really heard Mr. Dwivedi. It's a fact also. We haven't heard it.
Mr. Ranjit Kumar is there, Mr.
I know, but we are not going to count the numbers here and there.
No, we are not
No,
balancing.
we are not a non-number game.
But we have to contribute.
Okay, come to about 2 o'clock.
Obliged.
Only 3 councils. Decide among them.
kindly limit it to half an hour.
My lords, apart from the ex of.
My lords, kindly limit it to half an hour. Otherwise, it'll go on. Otherwise, it'll go on.
Apart from the.
Half an hour so that, and 10 minutes to us for rejoinder. Half an hour and 10 minutes.
Okay.
Deeply obliged.
He is, Mr. Sibbal can't fix the time limit already.
No, he only took 10 minutes. I'm winding him down to 10 minutes.
I'm saying 10 minutes only because.
It's our time limit.
Yes, my lords, we are saying, your lordship.
Okay.
It's our time limit. So that he may not.
And I hope one thing was very disturbing, the violence which is taking place.
Yes,
That's
absolutely. I agree.
Once the matter is before court.
Yes, nothing should happen.
Constitutional rights are concerned, we'll determine and decide.
That's,
Yes, this
that's
encourage.
why it's important for your lordships to put a quiet.
This is not a phenomenon
Absolutely.
that you can pressurize the system by violating, by.
I don't know who's pressurizing who. You
Unacceptable.
wonder who's pressurizing.
Unacceptable.
Must stop.
Must stop.
Violence must stop.
And let's also put it, both of us, we just discussed, there's certain positive points also. Nobody wants to highlight that. Please highlight those.
No, we would have,
Yes, absolutely.
I'm yet to highlight, I only responded that
Half an hour tomorrow.
the positive
We
points.
don't have to highlight, we discussed.
Oblige.
Within itself, Malad, my essential religious practice and faith must be reasonable and proportionate. So that's by and large, Malad, the broad submission under which we'll have to examine the provisions of this act, Malad. Let me straight away, Malad, kindly come to section 3R of the Bare Act of the Unified Waqf Management Empowerment. We have printed Bare Acts, Malad. Can we just hand them over to your lordship?
Comparative chart.
We'll just have the Bare Act first.
For JPC.
That's right.
Just for convenience. And Parliament also.
Allow me to give the Bare Act.
This is the act with the amendment.
Yes.
Now kindly see, my lord, on page 40, my lord, which is now deleted.
I have it here. But I see everything with the amendment.
Yes, Mr. Chairman.
Let us kindly look at 3R, definition of Waqf. Waqf means, your lordship has that?
Yes.
Waqf means the permanent dedication by any person, showing or demonstrating by any person, showing or demonstrating by any permanent dedication, showing or demonstrating.
अरे माँ जी फिर से पोषण चेक करने बैठी है, अब क्या होगा? आज तो मेरा भी नंबर है।
बड़ी बहू का वजन ठीक है, छोटी बहू का पोषण ठीक है।
Therefore, if I want to set up a Waqf or create a Waqf, Malad, I have to show that I have been practicing Islam for 5 years to the state. Why would I? It's my property. Why would I have to do that? If I'm born a Muslim, why would I? Why should the state be a judge of whether how good a Muslim I am or not?
Personal law will apply.
My personal law will apply to me, Malad, immediately. So, Malad, per se, according to me, Malad, this and then, Malad, what is that contrivance involved in the?
Given that we have a time constraint, I request you to
Check sound check.
each other primary.
All right.
Check
Now,
1,
Malad,
2,
this is
3, 4, 5, 6, 7.
Also cut down the time because this is the admission stage hearing. I request everybody not to repeat. Whatever has been said should not be repeated.
correct. But now I'll tell you, Lordship, what sections I'm challenging. I'm challenging this within itself, Malad, my essential religious practice and faith. Within itself, Malad, my essential religious practice and faith
Must be reasonable
and must be reasonable and proportionate. So that's by and large, Malad, the broad submission under which we'll have to examine the provisions of this act, Malad. Let me straight away, Malad, kindly come to section 3R of the Bare Act of the Unified Waqf Management Empowerment. We have printed Bare Acts. Can we just hand them over to your lordship?
Comparative chart.
We'll just have the Bare Acts first.
And present.
That's right.
Just for convenience.
But allow me to give the Bare Acts.
This is the act with the amendment.
Yes.
I have it here. But I see everything with the amendment.
Yes, Mr. Chairman.
Let us kindly look at 3R, definition of Waqf. Waqf means, your lordship has that?
Yes.
Waqf means the permanent dedication by any person showing or demonstrating. Does your lordship don't have the Bare Act?
Yes, we got the bearer.
So 3R, Waqf means the permanent dedication by any person showing or demonstrating that he is practicing Islam for the last 5 years. Of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of such property for any purpose recognized by the Muslim law as pious, religious, or charitable, and includes such and such and such and such. So, Malad, therefore, if I want to set up a waqf or create a waqf, Malad, I'll have to show that I have been practicing Islam for 5 years to the state. Malad, why would I? It's my property. Why would I have to do that? If I'm born a Muslim, Malad, why would I have to do that? Why should the state be a judge of whether how good a Muslim I am or not?
Personal law will apply.
My personal law will apply to me, Malad, immediately. So, Malad, per se, according to me, Malad, this, and then, Malad, what is that contrivance involved in the...
Given that we have a time constraint, I request you to say what
Sound check.
each other.
All right.
Check.
Now,
1,
Malad,
2,
this is...
3, 4, 5, 6, 7.
Also cut down the time because this is the admission stage hearing. I request everybody not to repeat. Whatever has been said should not be repeated.
Correct, but now I'll tell you, Lordship, what sections I'm challenging. I'm challenging this, Malad, 3R.
Yes.
Then I'm challenging, Malad, this proviso to 3. Proviso to 3. Provided that the existing Waqf by user properties registered on or before the commencement of the Waqf Amendment Act as Waqf by user will remain as Waqf properties, except that the property wholly or in part is in dispute or is a government property.
Which proviso?
This is the proviso. Waqf means, after Waqf means,
Page 6 of the compilation.
whereas they have, as your Lordship knows, Mallas, deleted Waqf
Yes.
by user.
Yes.
For the past, Mallas, they have maintained it.
Yes, fine.
For the future, they have Mallas. So that's another challenge, that who are you to say that I cannot create a Waqf by user? That is my essential faith and practice. So, Mallas, that's the second challenge. And this, every encroacher, Mallas, will have to be, it will be decided. Who will decide that? The dispute mechanism, Mallas. Now kindly come, Mallas, to section 3C. First 3A, Mallas. 3A, 3 capital A, subsection 2. I'll just read it, Mallas, and tell your lordships what the challenge is. The creation of a Waqf alal olad shall result in denial of inheritance, shall not result in denial of inheritance, rights of heirs, including women heirs, of the Waqif or any other rights of persons with lawful claims. Well, who is the state to decide that? Under what lawful claim are you talking about? Well, who is the state to tell us as to how the inheritance is going to happen in my religion?
Even under the Hindu Succession Act, the state has enacted the law, tells us how the succession will take place.
In Islam, Mallas, that's not the case, Mallas.
Are you saying that?
That's interference with 26.
Just a question before you answer. The Parliament cannot enact any law. Parliament has enacted law with regard to Muslims also. May not be to the same extent as case of Hindus, but it has enacted laws. It has enacted laws with regard.
No, I'm not on that. Mallas, because of 26, I'm sorry, Mallas. I'm on a normal, narrow issue of 20.
26 does not bar the legislature, the Parliament, as the case may be, to enact laws.
Subject to morality, public health, and public order. This is nothing to do with that.
But that's never prevented. 26 is never prevented either, because 26 is universal. It's secular in the sense it applies across all communities.
Yes, correct.
So, Hindu Succession Act, Hindu Guardianship and Maintenance Act, so many acts have been enacted.
I'm not. Please, all right, I'll just move on, but I'll just tell your lordships why the challenge. Why the challenge? Inheritance in Islam applies after death. They are interfering before that. That's the point. But that's the point only, Mallas. I'm just flagging the point, Mallas, so that there's no time. So that's point number 2.
It's the extent of this.
Correct. Point number 3, Mallas, kindly see 3C. 3C. In Mallas, page 9 of the book that I've given to your lordship.
Yes.
Any government property identified or declared as Waqf property before or after the commencement of this act shall not be deemed to be a Waqf property. Any property, government property identified or declared. So, if they identify or declare, it shall not be Waqf property. Then, 2. And I think the whole section is ultra vires. 2. If any question arises, whether any such.
Just one. 2 of section
3C, 3 capital C. Well, let's first 3C1. It's much better to look at that. Page 9 of this book, Mulat. VC1, may I read, Mulat?
Yes.
It says any government property identified or declared as Waqf property before or after the commencement of this act shall not be deemed to be Waqf property. So, Mulat, they can make a declaration says this is not Waqf property. Now, see how that is done. If any question arises as to whether any such property is a government property, the state government may by notification designate an officer above the rank of collector, hereinafter referred to as the designated officer, who shall conduct an inquiry as per law and determine whether such property is a government property or not and submit his report to the state government. Provided that such property shall not be treated as Waqf property till the designated officer submits his report. And there's no time limit there. Quite apart from that, Mulats, quite apart from that, what is that process where the government officer will decide in a dispute between the government and the Waqf that this is government property? You therefore have identified an officer who is part of the government, who will be a judge in his own cause, because he's an officer of the government. And he gives a declaration. Identifies and gives a declaration. This is again per se unconstitutional. Provided that such property shall not be treated as Waqf property till the designated officer submits the report.
So if the property is on lease, where is the rent? I'm sorry, I didn't want your lordship to hear this.
Yes.
So, Mullah, that's the third challenge. Challenge 4, Mullahs, perhaps even more serious. Declaration of protected monument or protected area as Waqf to be void. Any declaration or notification under this act or under any previous act in respect of Waqf properties shall be void if such property was a protected monument or protected area under the Ancient Monuments Preservation Act, 1904, or the Ancient Monuments or Archaeological Sites and Remains Act, 1958, at the time of such declaration or notification. So all these properties...
Just one. One reads it carefully. Last part says, at the time of declaration or notification. At the time when it was declared or notified as a Waqf, then that declaration will be void.
Yes.
If at the time of such declaration,
It was a protected monument.
It was a protected.
Correct.
But how many of such cases will be there? Because
Any there, Jama Masjid.
no, Jama Masjid was a Waqf property but before the.
That's correct. So that is a protected monument also then, Malas.
I'm just asking this question. On my reading is probably interpretation in your favor.
I see. I'm quiet then. And I'm quiet, Malas. I don't want to say anything more.
But that's something you have to listen carefully.
Yes, Malas. I appreciate it.
What I was saying was, if somebody's been declared a Waqf, before that monument was declared to be an Asian monument covered under the 2004 Act or archaeological monument under the 1958 Act, it will not make any difference. It's to continue to remain Waqf.
That's right. That's our submission.
Therefore, you really should not be objecting to it, except to the extent that something after it has been declared to be an Asian monument or covered by the archaeological survey, then it cannot now be created into a monument.
Correct. And now it can't be declared to be void. That's all.
even if it has been declared to be a Waqf, after the monument was notified or declared to be an ancient monument or archaeological, covered by the Archaeological Act, then that will be void. But most of the monuments, like Jama Masjid, or for that matter, most of the masjid, when you the ancient masjid, will be all protected. They will not be hit by this cross.
I'm sorry, I don't have the place. I appreciate that. When you go to a mosque, for example, which is part of a protected, take Sambal Masjid, part of a protected monument. What happens is the
Then they will
Mutawalli,
ask the other side what
the
to do.
Mutawalli,
We have understood your argument. We'll ask the other side.
so therefore this is now this is 3D Malas. That's my challenge there. 3E is the fifth challenge, Malas. Bar of declaration of any land in scheduled or tribal area as Waqf. Notwithstanding anything contained in this act or any other law for the time being in force, no land belonging to members of scheduled tribes under the provisions of the 5th schedule or the 6th schedule to the Constitution shall be declared or deemed to be Waqf property. Now, Malas, I have a chart here where all these Muslims are deemed to be scheduled tribes.
Isn't there a lot of laws across India which says scheduled tribes cannot transfer the property except with the permission of the court?
That's all right. But see what the extent of no land belonging to the scheduled tribes shall be declared or deemed to be a Waqf property.
Scheduled tribes have always, as far as land laws are concerned, ownership is concerned, they've been always protected. In fact, some of the legislation.
Right. I'm not one tribal. That's right.
Which is the right.
That's non-tribals.
Not to tribal. So a scheduled tribe member, even when they are protected laws like in Maharashtra, they
Wait for your turn. Mr. Simple can answer. Mr. Simple can answer that.
Correct. So, Malas, therefore, you can transfer it to a scheduled tribe.
Okay, understood.
Not only that, Malas, they shall be declared or deemed to be a Waqf property.
Understood.
So, Malas, that's the fifth point. Now, Malas, kindly come to the Central Waqf Council. Malas, your lordships may just note that under the 1995 Act, personal experience, maybe non-Muslims, Joint Secretary to Government of India, one member of the Bar Council, provided that 2 members of the board appointed under C shall be women, provided further that 2 of the total members of the board appointed under this section, excluding ex-officials, shall be non-Muslims. It's a complete takeover, Malas. It's a complete takeover through nomination. Now, Malas, if your lordship sees the 1995 Act, and I just presently give that to your lordships. The 1995 Act had all Muslims.
And a disqualification. Section 16 is disqualifies non.
That was, Malas, kindly see the council provision. I just point out the provision, Malas. Council provision was section 9 of the 1995 Act, all Muslims. Your lordship may just take it, it's all Muslims. And the board provision is section 14 of the 1995 Act, which is also all Muslim.
Next point.
And section 16 is a disqualification provision. For all
And from amongst Muslims, then there's a disqualification provision also.
that means non-Muslims are disqualified.
That's correct. That's correct.
Yes.
Now, Malas, the next section, Malas, is chief executive. No, let's leave that out.
chief executive officer had to be a Muslim.
All officers have to be Muslims earlier, including the chief executive officer. I know that. Now it's not a Muslim. Now kindly come to registration.
Yes.
On and from the commencement of the Waqf Amendment Act, section 36, Malas.
Yes.
1A, Malas. 36, 1 capital A. On and from the commencement of the Waqf Amendment Act, no Waqf shall be created without execution of a Waqf deed.
Wrong.
I'm not saying anything wrong, I'm just indicating, Malas. Waqf, kindly see, Malas, you can create a Waqf by user. You don't have to have a deed. If it is my property, Malas, as your lordship knows, if it is my property, Malas, I can create a Waqf. In the sense, I can allow somebody to say, have a shelter home there. I don't have to register it. It's my property, but supposing, forget about whether I'm the Muslim faith or not. Supposing my own property, I want somebody, I have to register.
There's no difficulty in that. You can register the work also because it will help you also have maintain a register of work.
No, that's another matter, but Waqf by user is abolished now.
Will that not be beneficial? I'm coming The question of Waqf by user, you have an issue, we'll ask the others.
Well, I'm just saying, Waqf by users is now abolished. It's an essential part of Muslim law and Muslim faith. And it's recognized by your lordships in paragraph 1134 of the Ram Janambhoomi judgment. The lordship just note that, para 1134, which says precisely that.
There is nothing wrong if you permit somebody to use. If you want to dedicate it,
Then you can.
dedicating it to all right. That is the concept.
That's right.
All that the section says is to avoid uncertainty, so that there is no, claim or a bogus claim, that you have a deed and portalize it.
I'm really not so much on that. Lordship is right. I'm just saying.
It will be passed beneficial.
Yes, yes.
In a way, it will be beneficial.
Wait,
Prevent any dispute.
let's move on, Let's kindly come to
Why
7.
it is a dispute? Really speaking, until this registration becomes a means.
There's a big problem here. I tell your lordship, they'll ask us now, and I'll show those provisions to your lordships. They ask us if there's a Waqf created 300 years ago, who created the Waqf? Give us information as to how it was created.
No, which provision is it?
Produce the deed if you can. So, they want all that information, and many of these properties were created hundreds of years ago. How will anybody ever prove it? And then, what happens is, and I just give you a historical background, which we'll argue when the main case is being argued. When the British came over here, what they did was, all these properties which were Waqf properties, what they did in the revenue record, they said Governor General. Now, on the basis of those revenue records, they say, if it's DDA, they say it is my property. And then, the collector will decide. So these are very serious issues that ultimately will have to be decided by a lordship. But prima facie, this is a matter because this will arise from all over the country. In every state, this issue will arise, which is why your lordship should take it over and hear and finally decide the matter. Let's kindly see 7A. Capital 36(7)(a).
Yes.
Where the collector in its report mentions that the property wholly or in part is in dispute or is a government property or is a government property, the Waqf in relation to such of the property shall not be registered unless the dispute is decided by a competent court, which could take 20 years.
The status quo as of now will maintain.
They are not saying that,
The state, no.
Not under 3C, your lordship, I read that.
3C, there's a contradiction emerging between this and 3C, like us the other side. There's a contradiction emerging.
That's right.
And how will they interpolate 3C with 7A to 36 will be an issue.
Any entity, any person, if he claims ownership to property, has to
Because
go
that
through
says anything which is government property, then 3C applies.
Yes. So how do you decide whether it's government property or not?
Here it says, as where government property is concerned, it has to be decided by a competent court.
That's the point.
If the decision is that of the collector.
That can't be, it's a judge in his own cause. And that's not a judicial process.
So argue that last.
That's not a judicial process anyway, Collector's process is not a judicial process.
Collector's decision is amiable to the tribunal.
No.
It's not amiable.
No, not that the section says so.
Section specifically says.
And or means also dispute. Kindly see, or is in dispute, which means they are not sure that this is their property. So nobody can deal with it, till such time as it is decided. So it's no longer be a Waqf.
Next point, Mr.
So that's 7A, Now kindly 10.
Subsection 10 of
Subsection
10 is the no suit, etc.
Yeah, no civil court will have jurisdiction. That's right. Then the
Which
tribunal.
one is that?
That's subsection
10 of 36.
10. No suit of this section, no suit, appeal, or legal proceeding for the enforcement of any right on behalf of any Waqf which have not been registered in accordance with the provision shall be instituted or commenced or heard.
Limitation period.
But that's the other very serious issue. Previously, under the 1995 Act, there's no limitation. I'll tell you, lordship, why.
Limitation can be always imposed by the government.
No, I'm on.
Like before 1995, we had the limitation.
Under the 95 Act, there was no limitation. I'll tell you the reason why. Because many of these Waqf properties were encroached upon. And therefore, in the context
No, we can't really say that if you impose a period of limitation, it will be wrong, it will be unconstitutional.
No, because
what Limitation Act has its advantage.
I'm not on that, I think the point I'm making is somewhat different. And the point is, my lords, that at that time, if within 2 years we did not file a suit, I can't file a suit now. Therefore, my lords, if the Waqf is created, say, in the 1930s,
There was no limitation period. That means you can always file a suit.
but now it says it has to, after 2 years.
If your work property is not registered, then you have to file a suit within 6 months and 6 months plus.
No, but these properties are not registered. These are Waqfs by users, many of them. So how will I file a suit?
So we'll ask them about.
So therefore, that's the other.
We have understood. We have understood.
That's the other issue, Malas. Yes, and they will claim adverse possession and encroachers will be legitimized. Encroachers will be legitimized in this process. And Malas, kindly see now 1A. That's another important page number 51, Malas.
1A of what?
1A of section 61, penalties.
Sorry, it's fine.
May I read that, Malas?
Yes.
It says, if a mutawalli fails to deliver possession of any Waqf property if ordered by the board or tribunal, carry out the directions of the collector of the board, do any other act which he is lawfully required to do by or under this act, provide a statement of accounts under 46, upload the details of Waqf, he shall be punishable with imprisonment for a term which may extend to 6 months and also with a fine which shall not be less than 20,000.
That's in case of violation. There are so many acts. Which
No, just
Anyway.
go to jail, Maharaj. 3B, Maharaj, kindly see.
Since 90s, it was
3.
Okay. That's all, Mr. Sip.
No, Maharaj, just one other thing. Then kindly see 85.
85.
Yes.
Yes.
No suit or other legal proceeding shall lie in any civil court, revenue court, or any other authority in respect of any dispute, question, or other matter relating to any Waqf property or other matter which is required by or under this act to be determined by a tribunal.
This
So that
is a new one or a...
No, it was there. It was there earlier also. But there was a tribunal. The difference is that the nature of the act has been changed. Originally, everything had to be decided by the tribunal. Here they have introduced 3C, which the tribunal...
That's a...
Why not Chief Justice? I have not forfeited my...
No, you have not forfeited. You're right.
Just to respond to one question that fell from your questions. The basis of our constitutional attack is that a Waqf is essential and integral to Islam. That was the basis of our attack. And religion, and particularly charity, is an essential and integral part of Islam. The original test essential was in 54. This other aspects, my lord, Mr. Sibal, I adopt that argument, both about the change in the nature of Waqf, the change in the composition and loss of control. Earlier, even the chief executive officer had to be Muslim, no longer. And lastly, my lord, many of these provisions are arbitrary and contrary to Article 15. That is the summation of our argument. I'm very grateful.
I just want to say this. Points have been covered, the same points. Waqf by user deletion is very serious because the statistic is that 4 out of 8 lakhs, 4 lakh out of 8 lakhs perhaps are Waqf by user. So by one stroke of pen,
I didn't want to interrupt you with this. There's an issue. You see, when we were in Delhi High Court, we were told Delhi High Court itself is built on a Waqf land.
It's all right. It's all right. It's all right. So
We
that's
were
the claim.
told that Oberoi Hotel is built on a Waqf land.
There are villages which are declared.
Mr. Mehta, please. We are also told Parliament is Waqf land. That doesn't mean.
I'm sorry.
Manoj.
We are told Parliament is also
we are
Waqf
not
land.
saying-
These
but
are imageries
don't-
created.
Just one minute. Don't misunderstand us that we are not saying that all work by users are wrongly registered, but at the same time, there's an issue and concern.
Absolutely, yes. Absolutely, yes. But what you are talking about is not individual abuse. You're not throwing the baby out with the bathwater. You are considering a per se legal abolition of the concept. Now, there's 2 issues arise here. Issue number 1. Waqf by user, is it a novel concept created? Is it something new? Your lordships in para 1118, I think it's 1134, it was para 1118 of Ayodhya's judgment, have traced that this is a very old lineage concept. Very old. Number 2 question arises legally. Have you removed the basis of the judgment? Also from Prithvi Cotton Mills through Madan Mohan Pathak, you have to do something to remove the basis. This act says that deletes. No, boss, 2RI is deleted. Just see the old 2RI. 2RI today, your lordship, in the book is a blank. In the footnote is given the original 2RI. Now that you delete. By deletion, can you remove the basis of a judgment? The judgment was not based on a Waqf by user. It's based on most ancient material. So that's point number 2. Point number 3, the practicality. 4 out of 8 lakh Waqfs are supposed to be Waqfs by individually. If I go and claim Parliament to be a Waqf, your lordship will not accept it. That I can understand. But you don't say the concept is bad. That's point 1. Point 2 is that there are 2 bodies. One is the collector, and one is this fellow called the designated officer. These 2 are the worst examples of judges in their own cause because of a series of provisions. Lordship will note that in this book, my learned friend has pointed out many of them. If you read them together, they are completely judges in their own cause, starting with 3 IIIDA. Just note that one. The collector is defined very, very broadly. Just see that definition. 3 IIIDA. Collector is not a mere collector as the lordship thinks, everybody, land revenue collector, deputy commissioner, or not any officer below the rank of deputy collector. Then please add to it these other provisions which say designated officers for other things. Till they decide, this shall not be treated as Waqf property.
That's it.
Thirdly, they will decide.
Mr. Sipal is already flagged.
Yes. Then, the third thing is, the third issue is, this is therefore the subordination, those provisions, my learned friend may have given you the chart, those provisions are very important. They are, just give me half a second. Sections of the Karnataka Hindu Religious Institutions Act, Dharmika Parishad Act, Religious Endowments Act, AP Charitable Act, and Sikh Gurudwara. The sections are there.
Dr. Singhvi, you already. That's all, Mr.
No, just 1 minute more.
For admission stage, this is something.
No, I'm not going to repeat, because I'm trying to, the problem is also trying to sift through that, which I don't have to repeat. There is a reason why we are saying that this word contrivance is intended to make the person visit the officer for lifelong. Apart from the fact that I have to prove I'm an adherent to Islam. That one part has been argued.
5 years.
It's a cumulative condition. I've done Islam for 5 years. I go and show my faith to somebody. Thereafter, there is an additional cumulative condition of contrivance. Now, this is a delightfully vague word. It will be, I will continue going to the office and I'll be under your control for life.
It already argued.
For life.
So take away something.
Can I answer the first question? Can I answer the first question? There are 3 reasons why this should not even be considered remotely for going to the High Court. Just 3 reasons very quickly. 1, it has all India ramifications. Your lordships would never say, that there should be High Court judgments of multiplicity and diversity.
Except that argument, then a lot of matters where legislations are
no matter will come, this. No, kindly see. Would my lord's countenance multiplicity of High Court judgments? Diverse High Court judgments?
We can direct one High Court. We can direct one.
The same thing will happen, your lordship will today, number 1, this is the most.
We have the benefit then of the High Court judgment.
So let me give you all the 3 reasons. Number 1, your lordships, there is no absolute bar in 32. There is a discretionary bar. 3 conditions. 3 conditions. 3 conditions. The first condition is Article 32. What is more, part 3 than Article 26, read with Article 25 directly. Secondly, your lordship will have all over the country, or even your lordship consolidates. What will be the point of spending this time, and ultimately it has reached the Supreme Court. So therefore, today, this is not that kind of a case where your lordship sends us to the High Court.
Okay.
And there is also an issue that your lordships should lay down the law definitely on this one. I have end by one thing. No, I'm saying only one thing.
Okay,
so
now 2 more.
No, 1 minute.
A quick constitutional point.
One minute more only.
2 sentences only.
I am saying this, my learned friend also meant the same, I'm sure. Some of these pernicious provisions, they have come into effect immediately. We are seeking a stay for the reason, your lordship has said in 3 judgments, Health for Millions, then Jayashri and Rakesh Vaishnav. The only argument is the new act. Your lordship doesn't stay the act. There's not a question of staying the act.
We'll come to that part little later.
No, only one sentence, when there is a status quo continuing from 1923.
Dr. Singhvi, why are you arguing that?
The first act came in 1913.
But I have a slightly different take on things. So I'm in 13.2, the Association for Protection of Civil Rights. Just give me a moment. I just want to point out one thing which is very, very important. Article 26, apart from 25, Article 26, let's please just see Article 26 for a moment. Mr. Sybil showed it to your lordship, but I want to just stress one thing. Because I'm deviating a little bit from this essential religious practices or essential religious features argument. I don't think it's necessary at all, as far as the Waqf Act is concerned, to show that it is a part of the essential religious practice of Islam. Please see 26. Freedom to manage religious affairs, subject to public order, morality, and health. Every religious denomination or any section thereof shall have the right, A, to establish and maintain institutions for religious and charitable purposes. Please note the distinction drawn by the framers of the Constitution. Religious and charitable purposes. Now, charitable purposes do not have to be to answer the test of essential religious features. There can be charitable purposes which have to do with a person who believes in Islam,
Understood.
but does not have to answer. Now, contrast and to manage its own affairs in matters of religion, etc., etc. Now, in Sirur Mat, your lordship said there will be certain secular aspects where the state can intervene.
So you're saying just read D also.
No. So and D,
Just read D.
to administer such property in accordance with law. Yes. So a law which
The law can interfere.
uh,
This accepts that law administration will be in terms of the law.
no.
May be framed.
Lordship's right. Preface.
Understood.
No. Just one thing. Prefaced with subject to public order, morality, and health. Those are the only three. Now, please contrast this with 25. 25 says.
Another provision.
Plus 25 says, subject to public order, morality and health, and to the other provisions of this part. All persons are equally entitled, etc., etc. This is why, Manoj, 14, 19, 21, etc., etc., other provisions of this part came in, for instance, in Reverend Stanislaus, where your lordship were considering the Freedom of Religion Act in Orissa and Madhya Pradesh. 26 draws a complete departure from 25. This is now your lordships have held in Sayadna and reiterated that even while referring Sayadna recently. Your lordships have held in the Dargah committee. Your lordships have held in Sirur Mat. These are all constitution bench judgments. And my lords, in the state of Rajasthan versus Sajanlal Panjawat, etc. Series of judgments. Your lordships have held that 26 bars state intervention except on provisions. Except for public order, morality, and health.
That's what.
Now, therefore, please, my lords. And just one last point. It's a slight repetition. What I'm saying about just one thing on 3C, that's very, very crucial because the moment a dispute is raised, it's not.
Correct, we have understood that.
It ceases to be a Waqf. I just want to put it in a context. Suppose there's a Waqf user for 300 years. Let's say it's a graveyard. Let's say it's a mosque. The moment somebody says, no, this is government land, you just have to say it. Then for the next 50 years, designated officer, tribunal, high court, Supreme Court, it ceases to be a Waqf. So the stay is very, very important in that context.
There's a reason in constitutional history why 26B exists, to manage its own affairs in matters of religion. Your lordship is from Amritsar. Your lordship may recollect that the Golden Temple in Amritsar had non-Sikh control. It required a whole Akali movement to regain control of their own Gurdwaras. So that is why the clue is to manage its own affairs. So own means necessarily an exclusion of somebody who is not your own. And that is the principle which has consistently been followed. From
I will make one submission.
I won't repeat.
Can I just take a cue from what my learner from Mr. Hegde said? I come from Kashmir. Lord, I come from Kashmir. I am a Kashmiri Pandit. Correct? There are temples over there. If tomorrow Muslims were to say because they are in majority, they are going to manage my temples as it is my temples are gone, would that be acceptable to the other side? Please juxtapose it, this proposition with the acts that have been shown. And I made something for your lordship's convenience. No, this is not a submission.
Lord, I'll make one submission.
Lord, one more thing. Can I just complete one more thing? Your lordship was seeing whether the decision of the collector. Your lordship was seeing whether the decision of the collector is final. Please see section 40 of the old act.
Yes.
Would my lord just see, it may help.
Yes.
You know, at the foot of the page, at page 38, these decisions where there was a dispute with regard to whether a property is, does my Lord Justice Vishwanathan have? Page 38.
Motion since deleted now.
It is, but it gives a perspective, my Lord. It used to go to the board, and if there was a dispute, it would go to the tribunal further. For correct.
Now it does go.
3C says the collector decides, he is high and mighty.
The tribunal is
That's all, I think that's the other side.
Lord, only one submission. Only one submission. Lord, kindly see, Lord,
You are
article.
paying for,
I will not repeat it, Lord.
no, you are paying for.
Lord, 103. Item number 103. Lord, we are appearing for a DMK party as well as Lord, Member of Parliament, Mr. Raja. Lord, your Lordship would kindly see, Lord, Article 26C. Lord, originally Article 31, Lord, where the property was there as a fundamental right, that was removed and, Lord, taken to Article 300A. But this 26C, Lord, remains to be there. So therefore, Lord, when can they tinker with the properties, Lord, of the religious, Lord, is subject to the public order, morality and health. Therefore, Lord, now this entire, Lord, amendment, Lord, they are attempting, Lord, they want, Lord, a probation period of 5 years, Lord, to certify that a person, Lord, is a Muslim. Lord, 3R, if your Lordship sees, Lord.
That's been already argued, please.
Yes. So therefore, Lord, my submission is against fundamental rights.
Lordship, without,
That's all.
just in terms of additional sections that we are asking for stay off, just 2 or 3
We
more
have not
sections.
argued, we have not argued on state, we are not.
Okay. He said, my lord, that the survey has to be done within 1 year's time. Lord, that was introduced, my lord, that was inserted in 2013.
Okay, yes. Yes, please.
In most survey, all the states are on record. There's a
Okay, that's all, please. Yes, please.
Just
Whereas item 63, can I?
Sorry, no more.
Whereas,
I'll have it put the curtain.
but whereas, just give me 1 minute.
Not required, we've heard you, we've heard the broad parameters on which you are, and in fact, the point which you have raised,
Can I just state something in 60 seconds, Manoj, if your Lordship allows? Because I had prepared a short note, but I take it that your Lordship doesn't want me to hand that over. I won't hand that. Just 2 points. Firstly, on 3R, there are 3 facets. One is, Manoj, that you change the definition. Everyone has said, Manoj, that the original definition included Waqf by user. Now, Waqf by user has been omitted under the new definition. And Waqf by user, Manoj, is a practice which is essential or fundamental to Islam itself.
we have understood.
And it can be trained.
Mr. MD, you're repeating,
Yes,
we have understood.
very well. Then point number 2, Manoj. Can I go to the next point?
Yes.
If your Lordship allows. Point number 2 is this, Manoj. The expression, Manoj, if your Lordship
No, we were
not
hearing
inclined,
you.
Manoj, I don't want to just stretch it further.
No, we are hearing you.
Very
No difficulty.
So point number 2 is the expression used in, my learned friend made the point, I just want to develop it a little more. The expression used is, Manoj, practicing Islam for a period of 5 years. Now, if this is an essential religious practice and it is protected by Article 25 to 26, it has the effect of suspending fundamental rights for a period of 5 years. So point number 3, just 1 more minute. Just 1 more minute, please. 1 more aspect. You use the expression that you have to prove that you have been practicing Islam for a period of 5 years. Now, are you going to tell me that, Mr. Ahmadi, you don't offer prayers for 5 times a day?
That's it this way.
No, so therefore there is
elaborate that argument.
no, therefore there is an aspect of vagueness. How will you determine that? Will you tell a Muslim?
That's what Mr. MD.
Will you prohibit him from dedicating a property?
That's all.
Lordship, I'll just point out
Just 2 more points.
No, Mr. MD, that's
Just, I'm not repeating
We
anything.
have heard you. I guess you have the most important points you've already had.
Lordship, I'll
Just 2 more points.
No more, Mr. MD.
I won't repeat.
3 provisions from
I'm not repeating anything, Manoj.
That's all, Mr. MD. I don't want to keep on repeating.
Lordship, I'll just highlight 2 or 3 provisions which have not been pointed out to my lords. My lord, the proviso to section 2, which says that any trust, even if the objects are similar to a waqf, if it's established as a trust, will be outside the purview of the Act, notwithstanding any judgment to the contrary. Lordship, this amounts to overruling the judgment in Sheikh Yusufbhai Chawala. A judgment of the Supreme Court, Lordship.
1 minute. They can always change the language of the statute because the trust also has certain benefits. Can't say that trust also has certain benefits. It's not that trust is deprived of all the benefits.
It's a question of regulation, Lordship. And this is just an
Then
overruling
what
of
by the special law, sections of the CPC apply. They take
One submission in 30 seconds.
Lordship section, again, Lordship, I'm not done. I'll just take a minute. Lordship section 104, which earlier allowed non-Muslims to also register, is a violation. So all of these, Lordship, are blatant violation of 300A of the Constitution, which is the right to property, saying that you can't alienate property, saying that you can't box property to the exclusion of heirs. Lordship mentioned Hindu Succession Act, and Lordship, Hindu Succession Act was a codification. It was not a question of imposing a law top-down contrary to personal laws. Here, saying that you can't box property contrary.
That there was
One submission in 10 seconds before your
by the
lordship
history of our 1956 Act. You know what happened.
one submission in 10 seconds before your lordships call upon the other side. Just one submission in 10 seconds. Plus your lordships, insofar as collector in 3C is concerned, it's directly in violation of the principle in Roger Matthew and Madras Bar Association. Because it's directly in the teeth of those judgments.
Yes, Mr. Mehta.
One second, I'll just not because
So, Mr. Mehta, now we want you to answer.
can I have 10
And
minutes?
then I'll have 3-4 questions to ask.
Yes, all your lordship's questions and the contentions will possibly, my lord, get answered, my lord, in what I'm going to submit. But at the outset, two things. Your lordships are dealing with a legislation, my lord, which has not just, my lord, came as a legislation. There was a constitution of a joint parliamentary committee. It, my lord, it held 38 sittings. It visited, my lord, all major cities, my lord, held consultation from 13th July to 7 November 23. My lord, examined 92.28 lakh memorandums, which are, my lord, considered, and, my lord, a bulky report is prepared. Thereafter, matter goes before both the houses of parliament, and your lordships, lords, are aware, detailed and, my lord, elaborate debates are, lord, made. Now, kindly come to the Act. Lord, kindly have a look at the Act. Some of the facts, some of the provisions, my lord, the other side missed, my lord, I believe must be by inadvertence. But please have a look at, my lord, the definition clause first. Please have a look at, my lord. My lord, if your lordships can take up, my lord, this chart, Lord, it would be relevant because, yes, Lord, please have a look at Lord, Waqf by usual. One of the most contentious issue, Lord, Waqf by usual. Lord, first of all, my lord, let me make one position very, very clear, and your lordships may kindly consider.
So are you now saying Waqf by user, even if it has been established by judges for particular case, one, or it is established otherwise, there is no dispute about Waqf by user. That now today stands void.
No, my lord, therefore I am saying, my lord, what was presented is not the correct statutory scheme. Lord, first of all, my lord, and examine my arguments based on this. Lord, I'll give two examples, my lord, not examples, my lord, in the case of Waqf. But I am a Hindu. I create a trust. My trust deed would say that all trustees would be Hindu. I would be, my lord, the settler of the trust. The trust deed would be the trust. And someone who will regulate the trust administrative secular activities would be the charity commissioner. My lord. Am I clear? It can be a public trust or a private trust. Here, in case of a Muslim, but Waqf necessarily under the Islamic law means dedication to Allah, Almighty Allah, for a particular charitable purpose, not accepted by the Islamic law. There has to be a Waqif. Waqif means the person who settles the trust. It's in parlance of Lord, which example I gave, settler of the trust. There has to be Waqif. Waqif would say that it would be governed by committee or an individual called Mutawwali, who all can be Muslims.
Correct. That's what Waqf by user is concerned. Right from.
I'm not on Waqf by user. Kindly
have understood that.
If your lordships can allow me.
You know only on Waqf by user.
I am, if your lordships can.
Fine.
Kindly bear with me. So far as Waqf is concerned, if it is governed as per the Waqif or as per the Waqf deed or as per anything by Muslims, this law does not come into the picture. What is Waqf board? Waqf board is the charity commissioner for Waqf. First, my lord, please bear the distinction between Waqf board, Waqf council, and Waqf itself in mind. No act, my lord, this amendment touches the Waqf itself. And Waqf means the trust.
Get up to 50% off on value addition. Mana andaride, Mana Kalyan Jewelers.
Give the first example. Nearest example will be the Charitable Endowments Act. The Hindu Religious Charitable Endowments Act. The states have enacted that.
Under somebody's supervision.
How is that administered? They are pointing out provisions that whenever it comes to Hindu religious charitable endowment, Hindu community which is administering it.
No, my lords. I don't wish to give examples. It will not be appropriate to give examples. I do not wish to, but take it from me. My lord, Hindu religious endowments, my lord, created by trust or by any other method, my lord, are governed by the whatever method is, but ultimate, my lord, the statutory supervision, control, coordination is by a body which may consisting of Hindus, may not be consisting of Hindus. That is why 25 and 26. Pardon?
Give us an example.
Let's not. No, let me.
TTD board doesn't have non-Hindus.
Bombay Public Trust Acts.
That's right. Trust is out. Trust is different. Trust is different because public trust.
There were several misstatements. No murmur from this thing. Let us maintain, my lord, a decorum. We are not arguing a religious thing. We are doing a legal thing. Howsoever,
Mr. Mehta does
please come to the proviso.
Mr. Mehta, let us be clear. As far as religious endowments of Hindus is concerned, normally it's the Hindus are
Ignore that part. Kindly come to the proviso. Kindly come to the proviso at page 6 of my compilation, of my, my lord, chart.
Yes.
Provided that the existing Waqf by user properties registered, please mark, registered on or before the commencement of the Waqf Amendment Act 2025 as Waqf by user will remain as Waqf properties. If they are registered, it will remain. Somebody says that why we did not register, and I'll come to that, my lord, what is the logic, and I'll satisfy your lordships. Except that I'll say that, Mr. Josefa, except that properties wholly or in part is in dispute. My lord, there is a civil dispute going on between either a private party and Waqf.
Why will it not remain a Waqf property? Let the civil court decide that dispute.
It would.
Or if it's a government is raising a dispute, let it decide that. Now what is it?
My lord, if the lordship allow me to
just
complete.
1 minute, please. This is the second part of the argument.
The difficulty is when the petitioner starts without pointing out the contours, the respondent, my lord, doesn't get to assist the court, my lord. That's
We have understood. We are pointing out the last part of it. First part we have.
I'll tell your lordship, my lord, why? Right from 1923, the first Waqf Act came in 1923. Registration of Waqf is mandatory. Statutorily, mandatorily required. You cannot have an unregistered trust, a Waqf, even Waqf by user cannot be unregistered, which was followed by the Waqf Act of 1954. 1954 also, it is mandatory to have your Waqf by user or any other Waqf registered. That was followed by the Waqf Act of 1995, the present Act, my lord, where also the Waqf Act, the registration of Waqf is not only compulsory, the Mutawali, which is Mr. Sibal pointed out that I'll go to jail. He is going to jail since 1995. If he is not registering his trust and not bringing it within the purview of the regulatory mechanism, there is a penalty provision of imprisonment since 1995. In 2013, the Parliament amended the Waqf Act, which I have pointed out. There also the Waqf registration is mandatory.
Mr. Tushar Mehta, just tell us one.
Yes.
Waqf by user, if accepted prior to the 2025 Act, is now touched. 1 minute, please. Is it now declared to be void or non-existent?
No, my lords.
Please take us, be careful about your statement.
Lord,
Waqf user, if already established and registered, say, 1 minute please, if already established, will it be declared in terms of the 2025 amendment now as void, or it will continue to subsist?
if registered, no. No.
36.
Yes, my lord, that is the exception.
1 minute. But then there's a catch.
See, yeah, my lords are right. Subject to please.
There are two catches. There are two catches here.
Yes.
One, it says, is in dispute.
For a court.
Where is it mentioned?
It's not. Dispute.
That's not stated. Is in dispute means, 1 minute please. Now, it doesn't say is in dispute. What do you mean by the term is in dispute? It doesn't say it's before the court or is otherwise in dispute.
Correct, my lord.
Number two, the issue is with regard to government property.
Correct, my lords.
Now, the fact of the matter is, before the Britishers came, we did not have any registration. We did not have any registration act. The Transfer Property Act. Now, the Waqfs say many of the masjids, etc., may have been constructed now in 14th, 15th, 16th centuries, 17th centuries.
They could have been registered after.
But to accept, to require them to produce a registered sale deed will be an impossibility.
But I am not registered for both.
It will be an impossibility.
Lord, my lords, possibly where I am not clear. Registration with the registering authority.
No, I'm
under
aware of
Waqf
that.
Act.
I'm now aware of that. But therefore, in
Not
most of the cases, say in case of Jama Masjid Delhi,
Yes.
the Waqf will be Waqf by user because the masjid was treated
Then
as.
nobody prevented them from not going and getting it registered.
So
In fact, it was mandatory.
Yes, current Chief Justice is putting it on. No, 1 minute. Some of your provisions are saluted.
Yes.
Some of them require clarification.
Yes.
What the Learned Chief Justice is putting to you.
Yes, Manu.
A simple case where a Waqf user, somebody after the act goes and seeks registration, you register, no problem. What if 3C is invoked and a stake is made by the government that it is government property?
Please.
Just answer, keeping one thing in. You have the land encroachment side. You have every state has land encroachment.
Yes, Manu.
Disputes have arisen where the government says this is Parambo land or this is the government land. A bona fide dispute of title is raised. This court says whenever there is a bona fide issue, it will be relegated to civil court. Collector or will not assume power.
They can still go to the tribunal, my lord. Let me complete. my lord.
That is the answer you have referred. What's the
What is being shown, my lord, is something, my lord. Except, my lord,
3C if you see.
now kindly come to 3C. Kindly come to 3C and, my lord, read, my lord, the way the government has read and the parliament has read. Not, my lord, I would not sensationalize. No person shall create a Waqf unless, my lord, page 3C would be page
Capitals.
Page 8, I'm sorry. Any government property identified or declared as Waqf property, identified means it is being known as a Waqf